I've got a section entitled Recent Developments in Pennsylvania Surety Law, and this is something we do every year. Because most of us in the room, whether you're on the owner side, the contractor side, the broker side, agent side, attorney side, is dealing with bond issues at some point throughout the law, throughout the year rather, whether it's a bid bond issue, performance bond, payment bond, maybe even a maintenance bond. And for those in the room that are doing public work, you know that you've got to provide at least performance and payment bonds anytime you're doing work for the Commonwealth, or anytime you're doing work for really any governmental entity or other agency, whether you're obligated to post those bonds under the Public Works Contractors Bond Law of 1967, or whether you're obligated to come up with those bonds under the Commonwealth Procurement Code. In addition, we all have situations where we're involved in bonds that a private owner might require or that owner's bank might require. So cases that come up in Pennsylvania construing and interpreting issues that arise under performance and payment bonds are relevant, to most of us in the industry. And so when we did our survey for 2013, we came up with 3 cases that we thought were worthy of note. There were more than 3 cases that were reported in the year, but we thought there were 3 that were especially interesting and relevant. The first one I'm going to talk about, Burke's Products versus Arch Insurance, is the one that, at least in my view, is the most important to the construction industry in general. And that case involved a interpretation of particular language in a payment bond and how it was applied and interpreted in accordance with some language in the Commonwealth Procurement Code, and I'll go into some detail here in a second. The second, and the Burke's case was also, the opinion was rendered by Pennsylvania Commonwealth Court, which is one of the intermediate appellate courts in Pennsylvania. And so when the Commonwealth Court issues an opinion talking about what the bond means and how it's interpreted in conjunction with the Commonwealth Procurement Code, it carries a lot of weight. That's an important opinion. Okay? The second case we're going to cover is Reginella Construction versus Travelers Casualty and Surety Company. This involves some local projects and some local issues. And this case is also very interesting in my view because it's one of the first cases we have construing Pennsylvania law, or at least discussing Pennsylvania law, which involves claims by Reginella against Travelers that are based on tort theories. Right? They thought that Travelers didn't treat them right and acted in bad faith, and they tried to sue them for it, and we'll talk about that. The third case, Conestoga Ceramic Tile versus Travelers Casualty and Surety, deals with the effects of a release and waiver form that was signed by Conestoga as a potential payment bond claimant very early in the project, and how that release affected it near the end of the project. And so we've included this as a kind of a reminder about how releases and waivers may work, and we'll touch on that very briefly at the end today. So as I mentioned, the first case, and maybe the most important one, Burke's Products versus Arch Insurance Company. In the basic facts of the case, to give it some context here, Skepton Construction was the prime contractor working for the Wilson Area School District for the construction of a new intermediate school. Skepton, of course, had to come up with performance and payment bonds, and it secured those bonds through Arch Insurance. I've included on this slide the particular language of the payment bond that was issued by Arch, because this language in the section I've got on the slide is really what was it was the whole issue in the case, and this was what the court considered and construed. The terms, and what the relevant portion here says that the terms and conditions of the bond are and shall be that if the principal and any subcontractor of the principal to whom any portion of the work shall be subcontracted shall promptly pay. Okay? And I've put in italics that phrase in the middle because the language of the bond itself imposes the obligation both on the principal, that was Skepton, and Skepton subcontractors to make payment. It had to do those things before the liability of the surety was extinguished under the express terms of the bond itself. Now this was a little bit, I couldn't tell from the opinion in the case where this bond came from. It's an Arch bond. It is not an AIA bond, but I don't know exactly where the language came from. I couldn't tell. I wanted to to try to determine from the opinion if the language of the bond itself was dictated by the owner, because sometimes that happens. All right, the owner may issue a bid package on the front end, has a form of a payment and performance bond in it, and you need to come up with a bond that has that exact language. And Mike, if you got any, I forgot to say, I know we have some surety people here today, so if you have any question or comment here as we go through these surety cases, please feel free to interrupt me. But the language of this bond was key, and it was just unclear from the opinion exactly why the language was drafted the way that it was. Skepton, the general, entered into a subcontract with R.A. Tauber for some concrete work. Tauber bought materials from Burke's Products Corporation. Okay. Skepton, the prime, paid Tauber. Tauber didn't pay Burke's for about $52,000 of materials. Skepton terminated the Tauber subcontract. Tauber went bankrupt. Burke's never got paid their $52,000 of concrete. Okay. Burke's filed a lawsuit against the payment bond posted by Arch to recover that money. Burke's could do that because it was a second-tier subcontractor. They were the lowest tier of subcontractor that still had claimant rights under the terms of the payment bond and under the provisions of the Public Works Contractors Bond Law of 1967. Now, because this project was a public project, it was an intermediate school for a school district, all right? Part 2 of the Commonwealth Procurement Code applied. And I'm not going to go through the procurement code, that's sort of beyond the scope of my little piece of this today, but at least some of you here know that the Commonwealth Procurement Code is generally divided into 2 parts. Part 1 applies to Commonwealth agencies, and it has a lot of information in it regarding contracting, bidding, bonding, bid protests, and other things that apply to contractual arrangements with Commonwealth agencies. Part 2 of the Procurement Code is much broader. It also applies to contractual arrangements with Commonwealth agencies, but it goes beyond that and applies to other types of governmental entities and agencies. School districts are covered. Okay? Part 2 of the Commonwealth Procurement Code is the part of the code that has all the language and provisions in it that deal with payment. Okay? So Part 2 of the code applies to the contractual arrangement here in this Burke's case, even though it's a school district and not a Commonwealth agency project. But under Part 2, Arch, the surety, figured it had a total defense to the payment bond claim that was asserted by Burke's under Section 3939 of the code, and I've reproduced that section here for you. This is known as the safe harbor provision, and it simply says once a contractor has made payment to the subcontractor according to the provisions of the subchapter, future claims for payment against the contractor or its surety by parties owned payment from the sub which has been paid shall be barred. So this is the, as I said, everybody calls this the safe harbor provision of the code, and it's supposed to mean what it says. It's supposed to provide some level of protection to the prime contractor and its surety. If you pay your sub, you shouldn't have to be made to pay twice. If you pay your sub and the sub goes bankrupt, the sub goes to the Caribbean or whatever, you won't have liability from the second-tier subcontractor's claim. Okay? Arch, the surety, argued that because it could prove that Skepton made payment in full to Tauber, the safe harbor provision acted as a complete bar to the claim of Burke's. Burke said, yeah, I know what Burke's argument in response was, I'm familiar with the safe harbor provisions of the procurement code, but hey, court, forget the code, read the bond. We have unique language in this payment bond, and that the bond itself controls. So that if the language of the bond provides a broader protection to claimant than does the Commonwealth Procurement Code, you need to focus in on the language of the bond. That the language of the bond could effectively waive the protections of the safe harbor provision of the Procurement Code. The court agreed. The court found that the language of the payment bond waived that safe harbor provision. The rationale being that a payment bond is simply a contract. And under Pennsylvania law, you focus in literally on what the language of that contract says. I'm not going to click back to the slide, but a few slides ago you have in your book, that's why I had reproduced the language in the bond itself, which made it pretty clear that the principal on the bond and that principal subcontractors needed to satisfy their obligations before the surety's liability could be extinguished. So why do we care about this? Well, unknown, unpaid subcontractors and vendors are a relatively common problem on any type of project. Matt mentioned it earlier in the mechanics lien scenario. You might have somebody with mechanics lien rights that you didn't even know was on the project, a second tier. Same problem here. On a public job, you don't have mechanics lien rights, but those second tier subcontractors that the general might not even know about, they also have payment bond rights, okay? That safe harbor provision under the Commonwealth Procurement Code is very valuable, okay? You don't want to waive it accidentally by using a form that waives that protection. I've got a couple practical considerations here on the slide. Be careful, old bond forms may be problematic. Frankly, as I mentioned, I don't know where this bond form came from. It wasn't an AIA form. I don't know if it was dictated by the owner, but taking some care and ensuring that you're only giving as much in the bond as you're required to give under your contract or by statute is really important. I suspect the surety industry has already caught up on this or will in the near future, but I suspect that there's probably bonds floating out there right now or that might be being issued right now that may not be drafted as artfully as you might otherwise want to ensure protections under this safe harbor provision. I've got a note here. Nino, our colleague Nino is going to come up next to talk about the Contractor and Subcontractor Payment Act, but just a note, we have like we have under Part 2 of the Procurement Code, we have payment statutes that apply to private projects under the Contractor and Subcontractor Payment Act, but that act does not contain a similar safe harbor provision that would protect a general contractor surety if the general pays the sub. All right, the second case I wanted to hit here briefly was Reginella Construction and Travelers. This case was pretty interesting, as I mentioned, because it was an attempt by Reginella to sort of do an end run around the terms of the bonds that Travelers had issued to it and the general agreement of indemnity that generally controls the relationship between the principal and indemnitors on the bond and the surety. In this case, Travelers had issued bonds to Reginella for two different school district contracts that had to do with work for the Moon School District here in Allegheny County. It was about $20 million of bonding. At the same time, they issued a bond to Reginella for a turnpike project in Ohio. Everything went okay on these projects for a couple of years, and for reasons that I cannot figure out from the opinion that the court has issued, the Travelers demanded payment on the school district projects, for the entire amount of the contract funds remaining in the custody of the district, including amounts that have already been earned by Reginella but not yet paid. I just can't tell what happened here because the opinion doesn't go into much detail. It seems clear, though, from the opinion that the school district had not actually declared Reginella in default of its contractual obligations, and it doesn't appear that there had been any formal payment bond claims either by subs of Reginella. The school district got the letter from the surety and said, okay, we're going to hold the money, we'll do what you tell us to do. Reginella said, hey, I need this money, some of this money's already been earned, if you don't keep the money flowing, the project's going to shut down, things are going to get worse, not better. The school district and Travelers rejected all of Reginella's payment proposals, which it alleged were designed to assure that all of the subs would be paid and that the project could continue. Reginella also alleged in this lawsuit, I don't know if it's true, but they alleged in the lawsuit that Travelers met privately with Reginella's subs and informed them that the project would be terminated before it was actually terminated. The project, in fact, did shut down. Reginella, for whether they didn't have the money or didn't want to spend it, couldn't continue to fund the subs without money from the owner, and the project shut down. At the same time, this project for the Ohio Turnpike was going on, and one of Reginella's subcontractors filed a mechanics lien on that project. Reginella asked Travelers if it could buy a lien bond to bond off that lien to satisfy the Ohio Turnpike Commission. Travelers said no. Ohio Turnpike then refused to pay Reginella until the lien was removed from the project, and that never happened. Ultimately, Ohio Turnpike Commission terminated its contract with Reginella for that work. Reginella claimed about $15 million in damages in terms of lost profits, loss of goodwill, loss of future business opportunities. And they filed a lawsuit against Travelers in federal court in the Western District here in Pittsburgh. And they took a totally, as I mentioned, they took a different legal tact. They said, hey, Travelers did all these terrible things to us, and they shouldn't have done it because Travelers is supposed to be on our side. They're our surety. They have a fiduciary duty, not only to not hurt us, but to help us. They're supposed to be on our team, okay? They also claim that because Travelers went to Reginella's subs and said, hey, you guys better start, demobilizing, this project's going sideways, we're going to terminate, the project's going to end. Reginella alleged that Travelers acted in bad faith and intentionally interfered in its contractual relationships, both with the owner and with the subs. Travelers filed a motion to dismiss at the very beginning of the case, before they had gotten very far down the path of litigation. They said, hey, Judge, as a matter of law, Reginella cannot assert these legal claims against us. Number one, they said they can't, you should throw out the claim for breach of fiduciary duty because there's no such thing as a fiduciary duty between a surety and its principal. And the court agreed, okay? That's noteworthy because there is a fiduciary duty, at least in some circumstances, between an insurance company and its insured. Okay, the court, as part of its analysis, discussed existing Pennsylvania law, which suggests, doesn't come out right and hold, but suggests that a surety bond is not insurance. And so there is no, just because there's a fiduciary relationship with an insurance company, that doesn't mean there ought to be one with the surety. Secondly, the court relied on the defense raised by Travelers under the so-called gist of the action doctrine. And the gist of the action doctrine simply says, if you and I have a relationship and it's based on a written contract, you're supposed to look at the written contract to determine our rights and responsibilities. Okay? You can't look outside of the terms. If you do something to me and I think that you've wronged me, but our relationship is governed by that contract, I've got to sue you for breaching the contract. I can't ignore it. That's the so-called gist of the action doctrine. So, secondly, Travelers said, hey, we have a general agreement of indemnity and we've issued bonds. That's the universe of our relationship. Forget about all this other stuff. Throw these tort-based claims out because of the gist of the action doctrine, and the court did that. The court threw out all of Reginella's claims. As part of their analysis, they said they acknowledged the Pennsylvania Supreme Court has not yet ruled on the issue of whether a surety owes a fiduciary duty to its principal, but it predicted that if faced with the issue, it would hold that it does not. Okay, as I mentioned, simply because the surety is not an insurer, and the court didn't think it was likely the Pennsylvania Supreme Court would choose to extend the fiduciary duty relationship to a surety and principal. On the other, the bad faith, tort-based claims I mentioned, intentional interference with contractual relations and bad faith, the court said, hey, it's no tort to breach a contract no matter how much bad faith is alleged. So the court basically said it doesn't matter how badly Travelers may have acted. If you can't prove, if Reginella can't prove that Travelers breached the terms of the contractual relationships, then it doesn't have a valid claim, and threw all those claims out. Why do we care about the case? Well, absent facts that might circumvent the gist of the action doctrine, a contractor is limited to asserting breach of contract actions against surety. In my experience in representing contractors, fighting sureties is like fighting City Hall. The terms of the general agreement of indemnity and of those bonds have been litigated for many years. They're crafted in a very specific way, and once you get sideways with the surety company, it's really, really hard to win that fight. This opinion by Judge Hornak in the Western District made it harder for contractors, not easier. Now, as I said, these claims were all dismissed at a preliminary stage. Reginella has appealed, and we'll have to track that and see how it shakes out. The last case I just wanted to mention very, very briefly, by far, and at least in my opinion, the least important surety case that we're talking about this year is Conestoga Ceramic Tile Distributors versus Travelers again. And what happened here, the opinion was really short, so the facts are a little hard to discern. But Conestoga was a second-tier material supplier. It never got paid. At some point during the project, it appears to have been long before the claim arose, the general contractor had Conestoga and the other subs and suppliers sign a waiver and release document, which purported to waive claims against all of the other contractors on the project. Conestoga never got paid, filed a lawsuit against the payment bond surety. The surety defended by using this waiver and release document that Conestoga had signed in the past, and the court said, hey, yeah, you should have thought of this. If you sign a waiver and release that releases your claims against the bonded contractors, you're also releasing your claim against the bond. Okay? That's not really new law. That's sort of been the law for a long time. But this release and waiver document was not signed in consideration of any payment actually received that had been signed early on the job. And I really included it because, you know, we talked about this a year or two ago in this year in review seminar. The law in Pennsylvania has recently become very clear that if you're signing waiver and release documents during the course of the project, like with your progress payment applications, and you say, I've waived all my claims, rights, bond claims, mechanics lien claims, and everything else through the date of the payment, it means what it says. You got to be real careful about, you know, the sort of form documents that you're signing as part of the project administration.